Senate Bill 8 and Senate Resolution 7. If we have some testimony from someone who has not testified at this point, please sign the list, and we're only allowing those who have not spoken previously. Okay. I want to recognize Senator Renee Unterman, who is the sponsor of the bill and had it passed out in the Senate. Thank you very much, ma'am. And if you have any remarks, please do not hesitate. Okay. Okay.
Thank you, Mr. Chairman and members of the committee. I know there's more members here now. I appreciate that from last week. But one of the questions that got asked was about the nexus of the commonality between adult entertainment facilities and purchasing sex. And I told you I had the first study committee, and I did find this. This is from 2008. That was the very first study committee, and it was in my office here at the Capitol, but the minutes are not in here, and I could not find them because I've moved offices twice since 2008, and I don't know. I would have to go back to Senate Research and see if they can find that. But what I did find in these notes was the context from a study that was done in Chicago that was used in this study committee, deconstructing the demand for prostitution, preliminary insights from interviews with Chicago men who purchased sex. And this is from May 2008. And the question was asked, and this is a scientific study, and I'll be glad to show it to you, where men buy sex, how men find women in prostitution. And this was Table 1, indoor locations in Chicago where 113 men bought sex. 52% was in a bar, 46% was in a strip club, 36% was in an escort agency, 36% from a private party, a lap dance club, 31%, a massage parlor, 27%, a brothel, 21%, a drug house, 11%, and a sauna, 10%. So there is documented evidence of the nexus between that connection of adult entertainment facilities and purchasing sex.
Thank you very much. Appreciate that.
Thank you.
That's right on target. Thank you, ma'am. Okay, I think we have just a few folks going to testify. I'd like to recognize Vernon Keenan from the Georgia Bureau of Investigations.
Mr. Chairman, members of the committee, thank you for an opportunity to speak on behalf of this bill. The Georgia Bureau of Investigation thinks it is a very important piece of legislation. The General Assembly in past years has given the Georgia law enforcement some very strong tools in investigating and prosecuting child sex trafficking. Well, I thank you for that. The more work that we do in this area, then we find other parts of the law that need to be strengthened, and this bill does just that. GBI has a unit which is dedicated to working child sex trafficking. We've been doing this for 2.5 years now. During the course of the unit, we have recovered 50 children that were being trafficked for sex. When I routinely meet with the men and women who work these cases at GBI, I ask them what is their most pressing need as far as resources to investigate and prosecute these cases. What they say each and every time is that there is a need for services for the victims. We have the tools to do the investigation. We're very good at what we do, but when we recover a victim, the treatment for that victim is long-term. We need, for their going forward with their life, they need this specialized treatment, and we need them to be available to help us prosecute the cases. It is not uncommon when we have a victim that we recover for them. Unless they're able to go into this specialized treatment, which is adequate, then they will flee. They do not trust law enforcement. They trust no one, so it becomes a revolving door. We've also found that when we do our undercover investigations to recover the child sex trafficking victim, because this is the area that we specialize in, we have limited resources, so we concentrate on the children. But when we do our undercover operations, often when the person responds to a Craigslist call or a back page ad, we do not know whether the person who's showing up is for sex is going to be a child or whether they are an adult. What we find out when we do confront the adult, we find out that many of them started out their life in the sex industry as a child, and they've been doing this for a number of years. This is their life now. They're an adult, but they started out as a child. So I would ask your favorable consideration for this bill to help the victims.
Thank you very much. Mr. Keenan, we have a question. Representative Quick, if you don't mind taking a question or two.
Thank you, Mr. Chairman and Director. Thank you for your testimony. I'm right here in front of you.
Yes, ma'am.
You mentioned 50 children, I think. Was that this year you're talking about?
In the last 2.5 years.
2.5 years.
That is what the GBI has done. Now, we work very closely with our federal partners, and but those are joint recoveries.
And you also mentioned Craigslist and Backpage as a point of entry, I guess, in terms of dealing with the minors being trafficked.
They're advertised. They're advertisement for escort services, and then the client goes on Backpage looking for the escort services. They give a number. You call the number and make arrangements for the service provider to show up. So the person showing up for a sex, and they're not advertising it for sex. It's escort. It's coded words. And they have also coded words in there, which leads us to believe it's a child that's is going to show up at the location.
And of those 50 children that you were talking about that the GBI had direct involvement with, how many of those 50 children had a connection to an adult entertainment establishment?
I don't know. I don't know that we know that. We're not working at the adult entertainment industries. We do our undercover through the back escort services.
Thank you, sir.
Thank you very much. No further questions at this time.
Thank you.
Mike Ennis from Wellspring Living.
Thank you, Mr. Chairman, distinguished committee members. Wellspring Living is privileged to serve and provide the restoration services to these minor children in Georgia who are sex trafficked that you just heard the director speak of. We see really the horrific side of exploitation and trafficking in an up-close and personal way. To the one who fully understands exploitation, which I confess we're learning more about every day, the only logical conclusion is these children are victims in every sense of the term. So often we hear the horrors of trafficking. There's no denying the impact of that. You've heard the statistics. I don't really need to reference those probably again. But this is not just an Atlanta issue. This is really a statewide issue. We know Atlanta carries with it economically one of the largest economic cities for trafficking in the nation, not something we're obviously proud of. I also would like to note, though, that Georgia in many ways leads in this issue in the sense that we provide 1/6 of all the beds committed to domestic minor sex trafficking in the country right here in Atlanta. And I think that's something that we can celebrate, though there's a long way to go. I would say this also, that the services that are provided here are done with much fewer resources than many other states provide and allow for that. I want to focus just for one moment on really the hope and the transformation side of restoration. We have, in fact, I just returned just about an hour ago from a graduation from our young ladies who we were able to get career jobs for four young women who started apprenticeships with tears streaming down their face and said, I've worked in minimum wage jobs, and for the first time, I feel like there's hope for my future and there's a possibility of transformation in the days ahead. And I think that's a critical part of the restoration that certainly we want to provide, and it is being provided. I have personally seen over the last 30 years in working in impoverished communities all over the world, I have seen hopelessness in ways that are unfathomable. But I wish for a moment you could see the hope in the eyes of these young women as they do see possibility and they see the transformation that can really happen. You would see the power of the investment that restoration can bring to these young women and how critical that part is, and especially to these children. A future where they can be reunited with their families, they can finish school, they can go on to college, they can accomplish their dreams and be a contributing member of our society and community, which is what we all desire. And I would say to you, we owe it to each of them to invest in that possibility for them. I strongly support this bill, would hope that this committee would support this bill so that we can continue those services and even improve those services. We have a moral and ethical responsibility to do so, to let these girls know that they're not a possession, but they are valued. They do have potential. Georgia can lead in that, and we can take some strong stands, and today I believe can be a part of that. I want to thank you in advance for supporting this bill, for supporting organizations like ours that are making a difference, and I believe Georgia has a bright future. I believe these young women have a bright future as we move this forward. Thank you, Mr. Chairman.
Hello, my name is Keisha Head. I would like to thank the committee and the chairman for hearing my testimony today. I am in support of Senate Bill 8. At the age of 16, I was young, beautiful, vibrant, full of life, rebellious, as all teens are. And unfortunately, because of my situation, I reached out to a childhood friend who introduced me to a guy named Sir Charles. I met this guy at a strip club. I was a runaway. Unfortunately, this guy was not my friend. He was a trafficker, unbeknown to me. This bill is very important because all the girls that were trafficked with me started in strip clubs. It was a grooming place for victims. It was an establishment that made me realize that I was not a child. I was easy accessible to men to purchase me, to victimize me, and to do whatever they wanted to with me. I am in support of this bill because during my victimization, it was a misdemeanor to traffic a child in Georgia. Today, it is a felony, and with accountability to traffickers and buyers. I am in support of this bill because accountability needs to be put in place for establishments because it is a breeding ground for victims. This is a starting place where they can be hidden to be groomed into the life of prostitution and accessible. 3 days I was in a strip club in Atlanta. Then I was trafficked down to Columbus, Georgia, where you didn't need a license to dance. It was a cover-up for traffickers to exploit young girls. And I just feel that if there's accountability for traffickers and establishments, that victims can be noticed and to get the services that they need to recover from this horrific lifestyle. Sir Charles was indicted and punished under the RICO Act, and I am here today only because of that, because I feel safe enough to do so. And I just thank you for your support of this bill, and from all survivors and victims, we thank you for supporting this legislation. Thank you.
Could we pose a question or two to you? if you won't mind, Ms. Head.
Yes.
Representative Spencer.
Thank you for testifying. Could you share your age, current age, with the committee?
I'm 35 today.
And when did you decide to come forward and tell your story? How old were you?
It was 5 years ago. I did not even know that I had been a victim of human trafficking until I saw a documentary. And I realized that, hey, that happened to me. And I realized that what had happened was horrific and it continues to happen, and realized it needs to be stopped.
And if you had an opportunity to confront your perpetrators and those that conspired to keep you in this business, would you, if you had the right to do that, would you execute that right if it was given to you?
Definitely execute that right and ask them, how dare they
Thank
take
you.
away my life.
Thank you.
Ms. Head, you mentioned that you met a gentleman named Sir Charles at a strip club, correct?
Yes.
And there were other victims that you were with at the time when you were in Atlanta?
The girl that introduced me to Sir Charles, she was a victim herself. She did not even know that she had been a victim. But I reached out to her for help, and she told me that she knew a guy that could help me. And she drove me to Atlanta to a strip club, and we met the guy. At the time, I didn't even know, I had never been in a strip club a day in my life. And we met on the outside of the strip club, so I didn't even understand what was going on. I was 16. I didn't ask a lot of questions at that time.
Right. Okay. And how many other girls do you know a number of approximately how many other girls were with you?
I was with Sir Charles for approximately a year and a half, off and on, and there were countless girls. The number I would say working on an average night would be in the hundreds. There were a lot of children on the streets of Atlanta during that time.
There was around the number of 100 children
being exploited on Metropolitan Avenue and through the strip clubs. Yes, there were a lot of 13, 14 babies.
Thank you. I don't have any other questions. Thank you so much for your testimony.
Thank you.
Okay. Jennifer Swain, if you could limit yours to 5 minutes or less, please.
Thank you, Mr. Chairman. To the members of the committee, today I would just like to read a statement from one of the Youth Spark community ambassadors. Youth Spark, formerly known as the Juvenile Justice Fund, is an anti-trafficking organization based on the front lines at the Fulton County Juvenile Court. This community ambassador could not be here today, so she asked that I read her statement. Her daughter, 17 years old, was trafficked initially out of an adult entertainment industry here in Atlanta. I am writing this pleading for positive change to happen for our children. I am a 47-year-old wife, mother of 3 living children and 5 grandchildren. I am a Youth Spark advocate and operate an outreach ministry. At 17 years old, my daughter got caught in the video girl craze. She wanted to be a singer or a background dancer and make the big money, be seen on videos with rappers, and live my own life because she felt grown, as she stated. She went from being a beauty shop assistant with me and then my best friend into a world that has taken over 10 years to try and come out of. She began listening to the streetwise girls and guys telling her how easy it would be if she just started dancing, stripping. Having to build up the courage to do it, she started drinking and doing small drugs, weed, and then was lured by her so-called friends into massages, as she would tell me. Those massages, as she was told to say by her pimp, her boyfriend, led her to being beat almost to death many times by the client and the pimp. She was given fake IDs and then forced to become a porn star. Her name and ID was used to lure other girls from other states to buy houses, to buy cars. She was arrested for prostitution and drug possession and left to deal with it until he felt like getting her. She would call and say she made $10,000, but we would be wearing Family Dollar rundown sneakers and clothes. Over time, she began the action of prostitution, stripping, and pornography. She got pregnant and began to change a little, but when you have constant contact with friends, clients, and boyfriends, even the law sometimes telling you that this is all you will ever be, it is hard for her to hear her mom and her family telling her that things she can change for the better. Our children make the worst decisions in life, sometimes thinking they are smart or grown. And all we have done in many areas growing up, however, we are now wiser ones, have to do something wise, like protecting them from the liars and the misusers, with laws that help to give them a fighting chance. We can no longer protect those that do these injustices against our children and young adults. We have to recognize that sexual predators prey on the young, however the young grow up and are groomed into the slave mentality of wrongdoing and choices. We can do the right thing in the legal system by changing the law to fit the needs of those lost their innocence, to those that run crime rings and recruit those closest to them. This happened to my family even though we have Christian faith and an outreach ministry and are involved in community service and activism. We did not understand stranger danger comes from the young and to the old. This is happening everywhere, from the inner city to the rural areas to the suburbs. Sincerely, a loving mom, Mrs. Joan Smith. Thank you.
Thank you. Ms. Stockdale, Heather Stockdale. Go ahead.
The last committee hearing, I handed out a case study of one of the children that we have worked with and are currently working with at Georgia Cares. Her name is Ashley, and wanted to provide her story real quickly. So you heard a story of a current child who was caught up in the life of trafficking. So Ashley, age 17, is creative, and her hobbies include dancing, singing, and fashion design. She describes her strengths as being outspoken, outgoing, and honest. Growing up, she was physically abused by her mother and consequently placed in DFACS custody at age 14. In the past 2 years, Ashley has had 10 different exploiters. Ashley ran away from her group home after she met her first trafficker online. She ended up in an area of Atlanta known as Bankhead, where her trafficker introduced her to exploitation by, quote, walking the streets. Over the next few months, Ashley worked for several traffickers in the Bankhead area, and soon after she became pregnant. She turned herself into the police because she felt that she had nowhere else to go. She was then placed in RYDC due to pending charges and had her baby while she was detained. Her baby was sent to a foster home, and Ashley was placed in a series of group homes following. After being released from detention, Ashley met another trafficker on Backpage. He picked her up and told her that she would be dancing for him for money. He took her to dance at an adult entertainment establishment in College Park and provided Ashley with fake ID cards since she was only 16 at the time. He was friends with the owners of the club, and all those involved in managing the club were aware that Ashley and other girls she was dancing with were underage. The trafficker had her dance in the club during evenings and work in hotels during the day, forcing her to repeat this routine for approximately 2 months. She was then recovered when law enforcement picked her up in a sting operation on Backpage.com and was placed at a CSEC-specific safe home where she is now receiving services from Georgia Cares. So that's just one story. Last time that I presented to the committee, I talked about, there are a lot of questions about the number of children that we're seeing. You heard from Keisha earlier about hundreds of girls that she came in contact with. And last year at Georgia Cares, we served 387 victims. I'm not saying that every single victim was trafficked out of adult entertainment, out of an establishment. There are many different means and many different ways that they become involved, but it is in entertainment establishments that we have heard time and time again, even as recruitment grounds or grooming grounds or meeting outside of these places, that youth can sometimes be first introduced to the life of trafficking.
Thank you very much.
Thank you.
Appreciate it. I don't have anyone else signed up to speak on the bill. Is there anyone else who'd like to be heard today? Yes, ma'am.
Mr. Chairman, members of the committee, my name is Elizabeth Apley. I've been in and out of the hearings and have been working on the issue of sex trafficking for over a decade. I'm here speaking on behalf of the Presbytery of Greater Atlanta and our 40,000 members and over 100 congregations across the state, and on behalf of Presbyterians for Better Georgia and the Central Outreach and Advocacy Center. We approach our advocacy from a position of faith. We believe in the values that our faith teaches us, and that's why we strongly support this legislation. Urge you to follow the urging and information that you receive from the witnesses and to submit this bill forward without amendment. Thank you for your very diligent attention to this important issue.
Thank you, Ms. Apple. Yes, ma'am. Come on. You can come on up to the mic.
I'll be very brief. I'm Helen Robinson, Director of Advocacy for the YWCA of Greater Atlanta, and we are here in support of this bill. I also just want to make a very quick comment that, as you all know, safe harbor laws have two components, the legal protection and the provision of services component. And Senate Bill 8 deals with the services component. Ultimately, we know that both components are necessary to reduce trauma and provide a path to recovery for these victims. They also are very intricately linked because law enforcement can often be the first point of contact to identify these victims. When sexual exploitation victims are brought into the system as suspects or arrestees, this can make them reluctant to believe that the state is trying to help them. It may also lead to further trauma. In Georgia, children under 16 can be detained and sentenced in juvenile detention centers, even though they cannot legally consent to sex, and 17-year-olds can be charged as adults for prostitution. They can use an affirmative defense in court and prove that they are victims, but the burden of proof falls on them. A legal safe harbor provision would reflect the presumption that these minors have been exploited and sexually abused by predators. And we need to remember that pimps and traffickers teach victims to be distrustful of health and social service providers, police, and other trusted adults. And these children believe that revealing what has happened to them could result in arrest and detention. And that can obviously become a barrier to them receiving treatment and rehabilitation. Thank you.
Thank you. No. Thank you. Without further ado, we're going to close off public comment on the bill, and the bill will now be on the rest of the committee. And at this time, we'll entertain a motion. Okay. All right. Got a move, do pass, and a second. Representative, let's see here. Representative Sharper.
Thanks, Chairman. I just want to go on record. I mean, we've had a lot of conversation over the last couple of days that we were here. I just want to go on record and let you know that I'm 100% behind us trying to do everything that we can possibly to ensure that these victims are well taken care of. I'm also 100% behind the enforcement to do everything we can to prevent a lot of this from happening. I have two girls, young girls, and daughters, and I understand what's going on as a paramedic. I've seen some of these things myself, and I'm just letting you know that through my conversation, talking with a few people and understanding what's going on. I don't want it to seem that I'm against it, but we have a duty, for one, to protect our victims and the people of the state of Georgia, and also I want to bring out the point that we also have a duty in order, people that do business in our city and in our states. So that's one thing that I was looking at, and my biggest concern was the amount of money that we're talking about assessing as a fee on the businesses, because to be honest, when you look at it, even though if we have the opportunity to regulate this, we're regulating it through finances. And the bottom line is, if we put this fee on them, it's going to pass down. It's going to pass down to some of the people that work in these establishments. They are citizens of Georgia as well, and their money is going to be hurt. For example, and I know friends that understand the industry. If you have to pay $150 when you show up at night to say, give me the opportunity to dance and make a living for my family, if this increase goes into them, these owners, they're not going to absorb it just on themselves. They're going to pass down to them and say, look, instead of $150, you're going to pay $200. And then if it gets higher and higher and you got a cover charge, now the guys have less money to donate or whatever you want to call it to the young ladies. Now everybody's money's dropping. And now some of these young ladies may have to look at other choices, even if it's prostitution, to try to get more money. So I'm just saying those are some of the pros and cons that we got to look at as a whole. And I would be willing, my thinking is, this is not a motion yet, but I would 100% be in favor of something that would say $5,000 fee or 1%, whichever is lesser. I'll be 100% all over that. I will have no problem whatsoever supporting that whatsoever. And another thing, we as legislators, we also have the opportunity, if we're talking about $2 to $2.5 million worth of money to help some of the agencies who are doing a great job, we can look inside our budget and put that into a safe harbor fund just like that. That's $2 million that we can decide to put that in our budget without having to bother the others, or just make sure we're doing everything we can to prevent them from keep on doing what they're doing, the pimps and the businesses. So I just wanted that to go on the record that the bottom line when it comes down to it, I'm for the people, I'm for the victims getting the help that they need, and most of all preventing what's going on.
Thank you, Representative Sharper. Representative Bell.
Thank you, Mr. Chair. Thank you so much, Keisha, for coming to tell your story. That was very brave of you. I feel it's something that we needed to hear. Metropolitan Parkway is my district. Used to be Stewart Avenue. I wonder if I knew you back then. I don't know how many people have ever seen this up close and personal. This is not a I want to be sexy type situation. These are young girls and young boys who are preyed upon by predators, adults who know exactly what they are doing. And they seek out children who come from disadvantaged backgrounds. They seek out children who are being rebellious with their parents. They go on the internet and they look for profiles. They look for pretty little girls and pretty little boys. This is an organized racket. This is not haphazard. This is not, I just go out today and decide I'm going to find some cute little girls. This is organized nationwide. The people who are trafficking young people here in Georgia have connections in New York, San Francisco, Thailand, Europe. They specifically call before they even set their reservations on planes to come to Atlanta. It is very well known and documented through documentaries, films, studies, that Atlanta is a landing place for this type of situation. It pains me that we would even consider putting the needs of a business before the needs of our children. As a juvenile justice committee, it is our responsibility to rescue our children. They must remain at the center of all that we do in this community. If those of us who know what's right in this world don't stand up for those who don't know how to make those decisions for themselves, who will do it? What if Keisha had someone in her life back then who could stand up and take her out of that situation before it got to the point? We think that children know what's going on. They really don't. I remember one day going to a CVS in my district, and there was a sweet little chocolate bunny girl running around. And all I could think is, where is her mama? Why is she running around this store by herself? I was there to get a prescription, and I went over to the pharmacy, and there were two young girls, African-American girls, on their cell phones. And so I asked them, I was like, is that your little girl? And she was like, yes, ma'am. I was like, well, don't let her just run around the store by herself. Anybody could take that sweet little baby and be gone. We sat down and we started talking. I don't know why they sat down to talk to me. One was 17. It was her little girl. She had two other children. One her grandmother was taking care of, and one her mother was taking care of. The other little girl was 14 years old, and all she was saying to me is, I want a baby. I was like, well, why do you want a baby? Because I want something to love, and that will love me. Come to find out, she had a boyfriend who was 42 years old. I sat there and talked to both of those young women, and I asked them about their sexual practices. And what they told me is, nobody's ever told me about birth control. And I'm like, come on now, did somebody not tell you about it, or did you just not listen? They said, nobody's ever told me about it. Your mother didn't tell you about it? No. Your grandmother didn't tell you about it? No. Where'd you meet this 42-year-old guy? He hang out at the strip club up the street. I was walking down the street, and, he made me feel good. Y'all, this is happening in the inner city. It's happening in rural areas, and it's happening in the suburbs. I hope we don't wait until it hits our own particular areas. We see that happening now with drug abuse. Now that it's hitting the suburbs, we want to provide assistance to everyone. Don't let this be that same situation, colleagues. Our children need us. This is not a perfect bill. This bill has been worked on for many years. I've been doing this work since I was 18 years old. Please don't allow a $5,000 fee, 1%, $10,000, $50,000. Our children are worth every penny of it. Thank you.
Mr. Chairman, I'm not sure if this is the appropriate time, but I'd like at your discretion to discuss a possible amendment for the committee to consider.
This would be the proper time.
I have discussed this amendment to create a true legal safe harbor to really replace into the bill, which I believe was a part of House Bill 200 and the good work that Senator Unterman did previous years along with Representative Lindsay. The reality is, as we discussed briefly the other day, is that a child under the age of 16 does not have the legal capacity to consent to any sexual act, and therefore it is my opinion that legally a child under 16 may not be prosecuted for a sexual offense if the child does not have the legal capacity. I have shared an amendment to restore an affirmative defense into the bill with the district attorneys, and this language was come from them in the past, and with the author and with the chairman and with other members of the committee that I've discussed this issue with. I have, I believe your aide has circulated this amendment, and I propose that following line 360, following Section 4.2, I make this a motion at this time that Senate Bill 8 be amended to include a true legal safe harbor. Specifically, if you don't have the language in front of you in your folder, it is to amend by revising Section B of Code Section 1636 relating to affirmative defenses to certain sexual crimes as follows. B, a person shall not be guilty of a sexual crime if the conduct upon which the alleged criminal liability is based was committed by an accused who was 1, less than 16 years age at the time of the conduct, or acting under coercion or deception while the accused was being trafficked for sexual servitude in violation of subsection C of Code Section 16546. I believe this bill can be strengthened by creating a true legal safe harbor and will restore to Georgia law what House Bill 200 created, I believe, 3 years ago. Could have been 4.
Let me make sure I have this amendment that you're offering,
Yes.
Representative Oliver. And that's following line 360?
Yes, sir, on page 11.
Okay.
It would be labeled as Section 4.3, and the remaining sections thereafter would be renumbered 4.4 and 4.5.
Hold on just a second. Yeah. Representative Oliver, the question I have here, and I believe may have been part of the evidence on the first hearing day for this bill, and I believe what the evidence was that there was a person who was a trafficker who was under the age of 18 and was involved in trafficking others, an active pimp type role, and I appreciate the provision for a safe harbor for a child under the age of 16, and I appreciate that. However, if we put this in the bill, the modification that you're asking for, the amendment,
The trafficker would have to be 15 years old to be the person that you were concerned about. A 16 or 17-year-old would not be covered by this language. In other words, there would be no safe harbor legally for a 16 or 17-year-old young man or woman who is trafficking other under 16-year-old children.
And it's my understanding that the evidence was there was an actual case that was prosecuted in Gwinnett County where there was a 15-year-old that was trafficking others for the purpose of human trafficking, human children. There was actually other children that were being trafficked by this 15-year-old.
I don't remember that testimony. I was in and out. I was here most of those hearings, but the district attorney, I don't remember him saying that, but please correct me if I'm wrong about that.
Well, I wasn't here for that hearing, but that's my understanding of the testimony. Do we have anybody from the district attorney's office here?
Mr. Chairman, good afternoon. Todd Ashley, Deputy Director.
Step on up to this microphone.
Yes, sir.
State your name, please, and where you're employed.
Todd Ashley, Deputy Director, Prosecuting Attorneys Council of Georgia.
Okay.
And I have with me also Ms. Charlotte Jackson, who is our domestic violence resource prosecutor. She's behind the post.
Okay. All right, go ahead. Could you comment on the...
We are familiar with a case out of Gwinnett County wherein I don't recall if she was 15 or 16 years old at the time, but it was a female who had an elaborate system set up in one of the restrooms at her school whereby she had bouncers essentially watching the door, and she had essentially a stable of employees inside the restroom who would provide sexual services for money at school. And if that's the case that the chairman is referring to, then to the extent that I had nothing to do with that case, Gwinnett County case, then yes, sir, that's true. That has been testified to previously.
Okay. All right. Thank you, sir. And
Yes, sir.
that was an actual case that was prosecuted. This was in Gwinnett County, and Gwinnett County, Georgia, for the
Yes, sir.
record.
Yes, sir.
And, okay. Now, do you have a comment on have you heard the language?
I have seen the language in the amendment or the substitute offered by Ms. Oliver, and the prosecuting attorneys are satisfied with that language.
With the language that Representative Oliver has proposed?
Yes, sir. Yes, sir.
Okay. Thank you, sir.
Yes, sir.
Okay. All right. Okay, now we have a motion by Representative Oliver. Is there a second?
Second.
Okay. Okay. Is there any discussion on the amendment? Mr. Representative Administration.
Thank you, Mr. Chairman. This is for Representative Oliver or Mr. Ashley. Just a question, point of clarification here. My understanding of the current state of law is a 13-year-old or 14-year-old, 15-year-old could be charged as an adult for rape, aggravated child molestation, aggravated sexual battery, 7 deadly offenses right now. Would this be offering immunity effectively for what would currently be an adult offense with original jurisdiction in Superior Court?
Difficult to respond to that without a fact.
Step to the microphone, please.
It's difficult to respond to that without a fact-specific scenario, but I'm not sure how that would work. If the perpetrator, if it is in fact a 7 deadly sin crime, and the perpetrator in this case is not the victim, see, because in the amendment, some of the perpetrators might be victims, okay? In the scenario that I think Representative F. mentioned, that would be a pure perpetrator scenario. So no, sir, I don't see immunity there.
Well, as a former juvenile court prosecutor, I'm familiar with circumstances where 2 juveniles that are participating in the crime can both be charged with, say, child molestation, even
of each other.
Yes, correct.
Yes, sir.
And so I guess that's the framework that I'm raising here under one of the amendment. Is it not possible that original jurisdiction would no longer exist in Superior Court? In fact, immunity would exist if a child under the age of 16 committed a 7 deadly of sexual nature against another child.
I do not believe that this would change that because the aspect of trafficking in scenarios of which the representative speaks, I'm not sure would be present.
Sir, have you read the amendment, the B1 of the amendment?
Before this meeting, yes, sir.
Okay.
Yes, sir.
All right, and you're satisfied that...
Just a second. If you'll suspend Representative Administration. Do you have a copy of the amendment that was proposed just now by Ms. Oliver?
Yes, sir, if I might grab it.
Please do.
Chairman's, and you're referring to B1?
Yes, sir.
Yes, sir.
Okay. And that's the language you're basing your testimony upon?
Yes, sir.
Okay. Okay. All right.
Mr. Chairman, there are other people that have specific interest in this provision. I'm not suggesting to you that you need, but I get people waving at me out there who want to say things, and I'm not sure how you wish to proceed.
Okay. Well, the bill is on the breast of the committee, and the committee may call a person or two, but at this point, we're going to move forward with other discussion with the committee. Okay. Representative Evans. Representative Quick.
Thank you, Mr. Chairman, and I've got other things to comment on, but I want to focus on the amendment because I want to be clear with Mr. Ashley and Representative Oliver as to what we're voting on, because I've got here two different elements of the language of this amendment on the affirmative defense. And Representative Oliver's says only that person shall not be guilty of a sexual crime if the conduct upon which the alleged criminal liability is based was committed by an accused who was less than 16 years of age at the time of the conduct, which, to Representative Efstration's point, seems to be an immunity for all sexual offenses for anyone under the age of 16. And then I've got another version of language that would, I think, read along the lines of less than 16 years of age at the time of the conduct, such person was being trafficked for sexual servitude in violation of subsection C of Code Section 16-5-46, which is what I understand to be the safe harbor for the sex trafficking that we've been talking about. So I just want to be clear what I'm voting on before I vote.
May I solicit assistance from Ms. Helen Robinson?
Thank you.
Sure. Thank you.
So I just want to draw your attention to the amendment is to Code Section 16-3-6, which relates to affirmative defenses to certain sexual crimes, and those are defined very narrowly as prostitution, sodomy, solicitation of sodomy, or masturbation for hire. So we would not be dealing with a pimp or a rapist in that situation.
Or other seven deadlies.
And
or
that's
other
what.
Seven deadlies.
Pardon me?
Or any 7 deadly sexual offenses.
Okay. All right. Okay.
Mr. Chairman, if Representative Quick is thinking about offering an amendment or a substitute motion to my amendment, that might be something for the committee to consider. And if I could ask her to tell us where her language came from and read it perhaps to the committee. Mr. Chairman, would that be appropriate?
That'd be appropriate.
Chairman Weldon, this was just language that I think came from the Prosecuting Attorney's Council, which would read the same as Representative Oliver's up to a point here, but it would read subsection B, a person shall not be guilty of a sexual crime if the conduct upon which the alleged criminal liability is based was committed by an accused who was, 1, less than 16, they have 18, but we're dealing with 16 years of age at the time of the conduct, such person was being trafficked for sexual servitude in violation of subsection C of Code Section 16-5-46, or 2, acting under coercion. The rest of the language is the same.
That's correct. We have that language drafted also, Mr. Chairman.
Is that the language you were referring to?
This was, yes, sir.
During your testimony.
This formed the basis of my response. Was the chairman referring to Representative Oliver's language or the alternative language just suggested?
The question I want to know is your comment on the amendment, which was Representative Oliver's language. Was that was your comment based on Representative Oliver's amendment or the language in the other that you had?
Yes, sir, based on the specificity of crimes that have been outlined in 16.3.6.
Is that yes, sir? It was the
yes, sir.
PAC language or the Oliver?
It was the Oliver language.
Okay.
Mr. Chairman, may I ask the prosecutor a question?
Yes.
Prosecuting Attorneys Association is okay with my language, I understand, because of the narrowness of it. But do you understand the other language that Ms. Quick was talking about to require a conviction of trafficking before you could assert the affirmative defense, or is it an alleged trafficking situation? I don't want to require a conviction of trafficking before the victim herself may have any legal protections. I think my amendment is probably sufficient, is sufficient to cover the 15-year-old rapist issue.
Mr. Chairman.
Go ahead.
Thank you. Representative Oliver, I maintain my concern just based on B1 of your language. If that was to be stricken and we were to proceed with the language under, I don't know if it's subpart 2 here, that would be perfectly acceptable, or the language read by Representative Quick seems to address my concern.
I would just, if I may,
go ahead.
Right.
To be, I don't think it, do you think it requires a conviction of trafficking?
No. I think it'd be an element to be proven as any other.
Then with that, I think that's fair. I believe I agree with you, sir. So with that understanding, I would accept as a friendly amendment Ms. Quick's language if she wishes to offer it as a substitute amendment.
And since we're being friendly, would you like it to be 18 or 16?
I would like it to be 18. I was taking the more conservative position, but I think 18 would be a better bill.
And while Representative Quick is thinking on that, PAC, this is the Mr. Ashley, this is the language that you had proposed, that PAC had proposed earlier, that actually contemplated less than 18 years. Is that correct?
Yes, sir.
So would the prosecuting attorney's counsel be okay with it being as 16 years as opposed to, 18 years as opposed to 16 years?
Less than 18?
Less than 18.
May I recognize Ms. Jackson?
Yes, please.
Charlotte Jackson with the Prosecuting Attorney's Counsel. The only thing we need to think about with the 18 is, I think this issue's come up before, is will those 18-year-olds be amenable to the services of the juvenile court?
We're talking 17.
Okay.
There will be 17. The person has to be 17 because it's less than 18. If it's 18, it doesn't apply.
As long as they're amenable to the services of the juvenile court.
Well, the juvenile court has jurisdiction over 17-year-olds
right.
in neglect cases where this would be properly categorized, in my opinion.
And it would be the opinion of the chair that this would be a bit broader, and it would capture the situations of 17-year-olds, which I think has a broader implication in terms of providing safe harbor, while being more narrow than the language that was proposed by Representative Oliver in the sense of the broader crimes that could be considered, which is the point that Representative Estration has made. So I'll put this back into Representative Quick's hands, who has offered at least some discussion about the language. Representative Quick. Let me, is it okay?
Sure.
Yeah. Okay, go ahead.
Some of us do not have this language in front of us.
Yeah,
Can we make a motion?
She's giving
thank
copies right now. So while we're talking about this.
Thank you. That was it. We're working on. We are not seeing it yet.
Tindy is passing out copies of the language right here, so I'm going to pass this down here. Thank you, Representative Spencer, and we'll just let that. So, Representative Quick is considering whether it's 16 or 18.
Okay. I think Representative Estration may have been trying to get your attention, Mr. Chair.
Okay. Representative Estration.
Mr. Chairman, I don't want to hold us up any further. I just will mention to the committee and just want to make sure this has been contemplated. 17-year-olds are currently charged under an adult court, and that this affirmative defense would apparently be raised in Superior Court as well as juvenile. Thank you.
Okay.
And so, Mr. Chairman, with that, it's my pleasure to offer a substitute to the Oliver amendment along the lines of the language that's now been circulated to the committee. And I'll read it if you'd like me to, but the salient provision is that it would be less than 18 years of age at the time of the conduct such person was being trafficked for sexual servitude in violation of subsection C of Code Section 16-5-46, And I'll just say I understand this to be the true safe harbor for victims of sex trafficking that perhaps Senator Unterman and others have been beaten up about in the past before my time under the Gold Dome. So,
and I think that's a good improvement on the amendment I offered, and I think Representative Quick certainly consent to that substitute amendment.
Okay. And okay, got a second. We got a substitute amendment. That'd be the Quick substitute amendment. And just for clarification, Representative Quick, after section 16-5-46 semicolon or, and then there's a new paragraph 2, and that new language will be acting under, and then that would be included in your amendment. So it's just as written as passed out.
That's correct, Mr. Chairman.
Okay. Do I have a second on the substitute motion or substitute amendment motion by Representative Quick?
Second.
Have a second. Any comment or discussion of the substitute amendment? Hearing none, the substitute amendment is adopted. Then we're back to the Mary Margaret Oliver motion for an amendment, which is now the substitute amendment. Is there any comment or discussion of the Oliver amendment? Well, I see. I got one. Let me see. Representative Waits.
My comment has nothing to do with that. It's regarding.
Just a second. I'll get you. Okay. Representative Welch.
No, I'll wait.
Okay. Okay. Hearing no comment or discussion, the substitute amendment is adopted. All right. That'd be the no. It's adopted. There's no objection. It is adopted. Okay. Now. Okay. Representative Quick.
Thank you, Mr. Chairman. I've got just a few things I'd like to discuss about the bill, and I'll have an appropriate amendment perhaps at some other time. But I want to be clear that, as we've just heard, I support the true safe harbor for sex trafficking victims, and I certainly support what's in the bill about enhanced criminal penalties and forfeiture as a tool for a true criminal enterprise, and that funding being dedicated. But I have an issue with the creation of a new commission to do that work, and I would just recommend that the committee instead consider allowing this work to be done and any fund to be administered through the Office of the Child Advocate and the Child Advocate Advisory Committee, and whatever amendments would need to be made to accomplish that, so that another layer of government is not created and another fund to keep up with. So that's one area that I'd like to discuss, and I don't know if there's what the pleasure of the committee might be.
Representative Quick, we're going to discuss, this is on the bill's on the breast of the committee, so we're going to fully discuss and amend as necessary. If you have other comments, now would be the time.
I do, Mr. Chairman, on lines 303 and 304, I would just call to everyone's attention that the bill makes it a misdemeanor if a person who has a duty to collect and remit the sums to the state in some way does not do it, is the way that I read that, which would be to the clerks. And so I would offer an amendment to delete lines 303 and 304.
Okay, so that would be removing the stick, so to speak, from those who refuse to collect the fees.
Well, I think it could also just be inadvertent, and that's. I think it just creates a situation where we're punishing the court clerks for an accounting issue that the state should deal with separately in some way other than a criminal prosecution.
Okay. All right. Any discuss? Is that a motion?
I move to amend.
Okay. You got a second? Representative Allison. Any discussion on the motion to delete lines 303 and 304 from page 15? Representative Oliver.
I'm trying to read this quickly to try. Isn't there an interpretation that 303 and 304 imposes possible misdemeanor sanction upon the strip club, the adult entertainment entity, and not the clerk of the court? That's what I'm trying to understand. And I know that in all our mandatory fee collections, I can't remember if in our mandatory fee collection sections the clerk has ever been sanctioned in this manner. I should know that, and I just don't remember. I certainly want to make it a misdemeanor of the adult entertainment entity not to remit.
Okay. 22. Go ahead. I'm going to ask Ms. Travis to respond to you on that. Ms. Oliver.
The language is the same as another fund that we copied it from. So it already exists in another code section where we're collecting monies and we put an imposition on the clerk to forward it. That doesn't mean that the policy could be different for this fund, but I'm just trying to tell you we stole the language from elsewhere.
And in your view, because your view is more important to me, pretty important to me, we're not imposing a possible sanction on the adult entertainment entity for failure to remit?
No, I believe this is on the clerk because this doesn't have to do with the Department of Revenue collection. That's in 1521-209. This is in the add-ons for criminal offenses.
So it's accurate we're probably inconsistent on imposing this sanction in the variety of different add-on fees.
If you remove it, it would be inconsistent. If you leave it, it would be consistent.
Representative Evans.
I've never practiced criminal law a day in my life, but I'm sure there's plenty of people in this committee that can tell me. I'm pretty sure I'm right that a misdemeanor prosecution is the prosecutor or the solicitor has to decide to do that, and I think the odds that our solicitors or prosecutors are going to prosecute the clerk of court are low. And so, to the extent that this keeps the stick on the adult entertainment industry to pay this fine, I would oppose the amendment.
Representative Atwood.
Mr. Chairman, something the committee may want to understand may want to consider under line 304. If it is the interest of the committee not to strike inserting between who and refuses the word intentionally, they may split the baby and satisfy both sides.
Is that in the form of amendment to the amendment?
If the chair so wishes, I will so move.
Okay, that's seconded. So on the amendment to the amendment, which is, I'm sorry, that's not an amendment to the amendment. That would be a substitute amendment. Excuse me. Okay, on the motion of Chairman Atwood, which the motion is to insert the word intentionally on line 304 after the word who and before the word refuses, so it'll read as follows. Any person whose duty it is to collect and remit the sums provided for in the code section, or in this code section, who intentionally refuses to so remit shall be guilty of a misdemeanor. Is that correct, Mr. Atwood?
That's correct, Mr. Chairman.
All right. Is there any objection to the substitute motion posed by Representative Atwood. Hearing none. All right. Okay. Where are you? 24.
On this amendment is the existing language in there penalizes the clerk, and with the insertion of intentionally, it actually penalizes the clerk and the person responsible for remitting the fee. Is that correct?
I don't think that's accurate. I think that with the substitute motion made by Representative Atwood, the clerk could only be prosecuted if they intentionally refuse to remit the funds. Then only if they're intentionally refuse to do that, then they could be prosecuted as a misdemeanor. Okay. Listen, let me get these lights out. Representative Waits.
Just a quick question. If we take out the word on lines 303 and we remove the word collect and, wouldn't that only put the responsibility on the strip club provider?
This has nothing to do.
That's in a different section. In this section right here, okay, hold on just a second. In this section, it's the position of the chair that the clerk of court will be required to collect the fees and remit as required. The refusal to pay is in a different code section. Okay. Representative Welch.
Now, Mr. Chairman, I just wanted to echo again that the amendments that are being proposed with respect to lines 303 and 304 only apply to the fines that are collected, and the fines that are collected are fines that are collected by the clerk with respect to those that have been prosecuted for a certain crime. This 303, 304 do not apply in any way, shape, or form to the strip club fee that's being assessed.
Representative Kendrick. Okay. Representative Wilkerson.
Thank you, Mr. Chairman. Now, my children may argue with this, but how do you unintentionally refuse to do something? I mean, refusing, I guess forgetting to do it is one thing, but actually refusing is something different. So I'm just curious if adding that word intentional is necessary.
Well,
I mean, I'm fine with it either way. I'm just curious, do we need to add that word intentional in there?
I think that's for each member to decide, but it does appear to the chair that that's a clarification on intentional conduct. It's not they may refuse by failing to comprehend the significance of the statute, which would be closer to or akin to negligence versus an intentional refusal to do the job. And I think it'd be for every member to decide.
Okay.
Okay. Now, I think we're back on the substitute motion. Is there any objection to adoption of the substitute motion presented by Representative Atwood? Hearing none, substitute motion is adopted. Now we're back to the quick motion, which is on the substitute that was previously adopted. All those in favor of the quick substitute?
Can you restate?
Okay. Yeah, all those in favor, or all those opposed to the adoption of the quick amendment that has been substituted by the Atwood amendment, or Atwood motion. All those, is there any objection to adoption of the quick amendment as substituted? Okay. Are we adopting do you want to adopt the motion as substituted? Who we got?
I think this would be a point of order. Isn't it true that what we're voting on right now is whether we would like to insert the word intentionally between the words who and refuses on line 304, whatever we call it? That's what we're doing.
Exactly.
It's been a long day, Mr. Chairman.
It's getting longer. Okay. Any objection to the adoption of the quick amendment as substituted? Hearing none, the substituted amendment is adopted. Okay. Representative Quick.
Thank you, Mr. Chairman. I do have another amendment that requires a little background, and it involves this notion about what is a fee and what is a tax. Under Georgia law, a fee is defined as something, a required payment for a special privilege or a service rendered. A tax, by contrast, is an enforced contribution imposed pursuant to legislative authority for the purpose of raising revenue to be used for public or governmental purposes. Therefore, even the cases, I spent a lot of time this weekend and early this morning trying to read all the cases that have been provided to us in with particular attention to the two jurisdictions that have approved a legislative assessment against adult entertainment establishments. And the Texas court in particular made clear in its legal analysis that it was analyzing this imposition and this assessment as a tax. So I would move to amend the bill so as to change the word fee to a tax, which is what it is.
What line would that be?
Oh, it's throughout, Mr. Chairman.
Throughout. Okay.
Wherever it appears.
Representative Welch.
Because that, I'll speak first to the amendment, if I may. I think you probably want to get either a second to that before we discuss it.
You're right. Right. Is there a second to the motion to amend the bill and substitute the word tax for the word fee as the word is found in the bill? Awesome. Okay. Discussion on the bill, Representative Welch.
On the amendment that's proposed, the problem I have with just doing a general blanket substitution is that I can't find throughout the whole bill where that appears so that I can judge for myself whether or not that's going to alter the intention of the General Assembly. But it may clear up because our Senate Bill 7 speaks to an assessment, and an assessment has a broader context than I think fee or tax, and so in my mind maybe the better terminology would be that on line 307 where it says state operation fee, I would strike that language. My substitute motion would be to strike that language and insert the word assessment there. And then that would also appear on line 317 where it begins the fees collected. That would be assessments collected. And then again on line 308, I skipped this one, sorry. The state fee, it would be state assessment. And that would address, and then there's also it's also on line 323, the first word of that line. I got 317 already. But thank you for double checking me there. That is in the
Okay.
form of substitute motion, yes.
Okay. The on the substitute motion by Representative Welch, I'm sorry, excuse me. You're wrong. Yeah. Representative Benson.
Do we know that the word fee appears anywhere else in the bill? The caption on line 4. Anywhere else?
Yeah.
And Mr. Chairman,
Go ahead. Mr. Spencer.
To, I guess, a substitute amendment to the Welch amendment about replacing the word fee with assessment, I'd make a motion to state that any word that's mentioned in the bill using fee to be replaced with assessment. Just make sure we cover our bases.
Okay.
If that's appropriate.
That motion's out of order at this point. It may not be.
That's right.
Okay.
It's we're trying to capture all those, and I think that Representative Spencer is correct. There's a few on the first page that deals with the caption of the bill, and I think that the one that we need to address. See, there are additional fees and costs that are assessed here. On, for example, on line 4, but that deals with a different type of fee that's assessed in the bill. So, line 18, however, does deal with that state regulatory fee assessment that we were talking that Representative Quick has raised. So, line 18 would need to say regulatory assessment there. And then going back to page. On line 53, there is that same assessments fee there on line 53. That would be assessment, and that would, I think that would cure the fee issue. And if I could, Mr. Chairman, if we go back to line 322, 323. It says, including a method of appeal by an adult entertainment establishment that is assessed, and I had assessed a assessment. It could just be that is assessed pursuant to this code.
Okay, we're going to take this. We're going to do the lines 305 through 323 first. That'll be the first Welch substitute amendment. As well, okay. So you're changing, you're modifying your amendment.
I'll restate the
substitute motion.
On the first substitute, her Representative Quick's amendment is to change, as seconded, is to change the word fee throughout the bill to tax. And my substitute amendment would be that to go into specific lines and change the word fee to assessment, and the lines would be on 307, 308, 317, strike the words on 322, strike the word A at the end.
Hold on just a second. 307, 308.
317.
Okay.
Line 322, strike the word A at the end of the line. 323, to strike the word fee. on line 18, strike the word fee and insert the word assessment. And on line 53, strike the word fees and insert the word assessments. All right, in line 41, striking the word fees and inserting the word assessments. And then on line 161, striking the word fees and inserting the word assessments. Thank you, representatives, for your persistence.
Okay. All right, Representative Oliver.
We're back. I'm back to the discussion of the amendment.
We're on the discussion of the substitute motion.
This is an inquiry thinking 2 steps ahead. I'm not certain what the purpose of the changing the terminology is, but I'm assuming that you would object to a fee, an assessment, or a tax. And that an amendment is coming to delete all of the fines, fees, tax, assessment issues. Am I right or wrong?
From me? Not from me, Representative. I just call this the Truth in Legislating Amendment.
Okay. Okay, that's helpful.
And that's an aside, as everybody's considering it. I mean, the taxing authority of the legislature is part of what saves the analysis and saves these type of schemes from attack, in my legal opinion. So it also, not only is it truth in legislating, it perhaps helps save the bill from future court challenges if they come from the adult entertainment industry. It's just my humble opinion.
That's helpful to me. I'm just trying to figure out why we're doing this, and that's a helpful answer. Thank you.
Representative Evans. Representative Atwood.
Thank you, Mr. Chairman. I would ask Ledge Council this to help me make my decision. Is there a definition in case law for assessment, also for tax and fee?
I don't know. I'd have to look at it.
Because when we're inserting words in a bill, I think we need to define them, and maybe Representative Quick can answer that, but I think we need to be very clear, very specific what we put in case law, to legislation, I mean. Thank you, Mr. Chairman.
Representative Raffensperger.
I guess to the point of assessment versus tax, it just says in my little Google search that assessment says the evaluation or estimation of the nature, quality, or ability of someone or something. And I think if we were just clear and concise that a tax is a tax, and then then we're not really playing, we don't get into these questions of what we're really assessing, and we just call it a tax. I think that would be cleaner and may not end up with difficulties down the road in a court situation.
Representative Welch.
My experience with dealing with local government issues and dealing with the issue. I think that the question always is a question that the court can decide on, whether it's a fee or a tax. The terminology is, and what I've done is chosen the word assessment so that it's broader in terms. And in general local government practice, we utilize that term in a broader sense so as to allow for the interpretation that's necessary by a court should that need be necessary. So all I was doing was trying to go to a broader terminology and ensure that that was the treatment given to it by the court.
And Mr. Chairman, I mean, truly, my intent here is that I would not like to leave Senator Unterman's bill to the interpretation of a court. I would like to make it clear that it is a tax. The legislature has the authority to tax, and there's nothing to argue about, and we leave no doubt. That was my intent.
Okay, any further comment or discussion on the substitute motion? I hear any objection to the substitute motion by Representative Welch?
Object.
Object. Okay, all those in favor of the substitute motion indicate by raising a right hand. All those opposed? Okay, all those opposed, raise your hand. Raise it up there where I can see it. Opposed to substitute. 8. Okay. All those in favor, raise your right hand. Okay, the motion carries. The Welch substitute motion carries 10-7. Okay. Representative Quick.
Nothing further, Mr. Chairman. Okay. Hold on just a second. Representative Waits.
Mr. Chairman, given that a number of the strip clubs that we're referring to are going to be based in the city of Atlanta, I just simply want to remind the committee of something that happened many, many years ago. Many of you may remember when the adult entertainment fee was assessed. I think it's $300 right now. And essentially, the original proposal was at $1,000. This fee was passed on to the performers. And I'm very concerned with the concern that Representative Sharper has raised that we may be potentially encouraging prostitution, essentially, because this happened many, many years ago. They took the fee from $1,000 to $300, and I don't want to see that happen. I am a strong proponent of this legislation, but I do think that we are in order with putting, if you go to section 308. Is it line 308, forgive me.
Okay.
And if we use the language or less, I think that would potentially save some of this from being passed on to the performers, which is what happened in the case of the city of Atlanta with the adult entertainment fee. Keisha, do you remember what I'm talking about? No. The fee, the $1,000 fee back in the day? No. You don't remember the fee? Okay. But there was a $1,000 fee, Mr. Chairman, and it was lowered for that very reason. If you attended the council meeting in question, the room was packed with performers who opposed the fee. Mm-hmm. So I just want to remind everyone of that fee that's in question, and this was specific to the city of Atlanta only. Thank you.
All right. Representative Welch.
Mr. Chairman, we have a couple of amendments I'd like the committee to consider.
Before we go to that,
okay.
Go ahead. Never mind.
No, I can wait.
Go ahead, Representative Welch.
The one amendment has been a venue amendment. This was from House Bill 280, and this would be an amendment to insert language that we've already to OCGA 41-1-12. This is on the document that you were that was just passed out to you a moment ago that dealt with the Mary Margaret and Quick amendments. It's the first section up above that deals with a violation of the code section is declared to be a continuous offense, and the venue for such offense shall be considered to have been committed in any county where, 1, there's a sexual offender is required to register, 2, the accused fails to comply with the requirements of the code section, or 3, an accused provides false information. This is also an amendment I think that PAC is favorable with in terms of adding this venue language, and I would propose that it be between lines 427 and 428.
Got a motion and a second. Okay. Now, Representative Welch, would you, all right, this is on lines, what?
This would be lines, between lines 427 and 428 would be the proper ordering. So that, and we'll renumber the sections, authorize the Legislative Council to renumber the sections accordingly.
Okay. So this will be section 4-4?
Yes, sir.
Is that right?
That's
Council?
correct. Well, it won't because we've already renumbered the
Okay.
other sections. So.
Okay. So the motion is to renumber sections as is appropriate in consideration of the amendments, and insert language as provided as follows. Any violation of this code section is declared to be a continuous offense, and venue for such offense shall be considered to have been committed in any county where, 1, a sexual offender is required to register, 2, an accused fails to comply with the requirements of this code section, or 3, an accused provides false information, period. Is that the motion?
Yes, that is the motion.
Okay, with a second. I hear any objection to the second, let's see, what the second or third Welch amendment as
It was the motion was made by, I think, Representative Jacobs and seconded by Representative Oliver.
Okay. Any objection? Hearing none, the motion is adopted. The amendment is adopted. Okay. Representative Jacobs.
Sorry, just to follow on the whole assessments debate, I think it would make sense on line 309 after the word fees to add the words and assessments. That's the one place we kept fees in there. 309. Oh, 308? No, 309. Right.
So that the language would read, after the period following the number 5,000, said this state assessment shall be in addition to any other
fees and assessments.
Fees and assessments. Okay. So on 309, after the word fees and before required, insert assessments.
Mm-hmm.
Second.
Okay. Any discussion or comment on the first Jacobs amendment? Hearing none. All those, or is there any objection to the first Jacobs amendment? Hearing none, the amendment is adopted.
Now it's perfect.
Chairman, I have another amendment, if you would.
Representative Welch.
Representative Atwood had made I think a good point at the first committee meetings discussing the issue of false imprisonment, and I just want to pose the question as a motion for discussion, and that is dealing with lines 404 and 405 on page 13. And I would like to, you'll see there that Representative Atwood had indicated to me and to others, I think, that there was a concern about false imprisonment being a reason to be listed on the registry. And so this was, it's a broad, false imprisonment could apply and technically to a lot of different situations where an uncle or brother or an uncle or an aunt or grandparent was actually engaged in false imprisonment, and the feeling was, and I'll let Representative Atwood express it more, but I did want to direct Representative Atwood's attention to lines 426 and 427, because it may be useful to delete 404 and 405, because I think it's captured in 426 and 427, and I have discussed this with Legislative Council before making this proposal.
So the motion is to delete lines 404 and 405?
That's the motion, yes, sir. And I'll let Representative Atwood, if you'd like to chime in and speak to that.
Be happy to, Mr. Chairman, at your permission.
Representative Atwood.
The concern is this: false imprisonment by itself is what essentially leads up to kidnapping with no asportation. And if we were going to keep it, I could see a situation where one family member, let's say, has custody of the child, says, you're not going anywhere, you got a young man acting up, you're staying right here, has a fuss with the sister. That actually happened in my family one time. And sister says, you don't have the permission to do that to my child, and that's the problem. My first thought was, let's amend it and put false imprisonment in some way tied to the other offenses that we have in here of a sexual nature. And I certainly don't want falsely imprisoned if it's leading up to that or involved in that. But looking at 426 and 427, I think it probably would capture it if you, and we could still use that if it, where's Representative Welch? If it was in fact struck. I think I agree with you on that, Andy.
Okay. Do I hear a second? Oh, I'm sorry. Excuse me, Representative Atwood.
I just wanted to point out to Representative Welch, too. I think we have the same thing on 373, 374, I believe. I just now pulled that up.
And the reason why I didn't do that is because what we're doing in this bill is we're actually going to trigger the effective date on this new law that will come about with this bill's passage. And perfect. If that is the case, if not, we'll have to revisit the issue, I think, later than trying to deal with it here. And that's why I did not do the changes, the similar changes to 373 and 374.
Any further comment or discussion of the Welch Amendment to delete lines 404 and 405? And just for the clarification for the committee, the language in lines 426 and 427, which reads, any conduct which by its nature is a sexual offense against a victim who is a minor, or an attempt to commit a sexual offense against a victim who is a minor, is a very broad approach to dealing with these elements of the offense. And the false imprisonment that's addressed in lines 404 and 405 will be deleted, and but it doesn't. This statute still catches that offense. So if someone's holding a child as false imprisonment, they can't be charged for that. The child will still be able to shoot now.
No, it would be, you're right, Mr. Chairman, it's a catch-all, so that if it's false imprisonment with an intent to engage some kind of sexual activity, then the person would be on the registry. But if you just leave it as false imprisonment in the statute as it is, then a false imprisonment with no intention of having any sexual conduct involved would then land someone on the registry, which was Representative Atwood's concerns. So what we're doing is we're now saying that you'd have to have someone would show false imprisonment where there's some conduct for a sexual offense, and then I think that would remove the capture of the unintended capture of people that in the registry that was not, I don't think, intended.
Is there any objection to the Welch Amendment? Hearing none, the Welch Amendment is adopted. Without objection.
And Mr. Chairman, to address a couple of concerns I think that was raised by Representative Coomer, there is a broad latitude given to the governor on lines 219 through 222, whereby he could disallow or disapprove the funds being issued or not authorize disbursement of the funds if it's not been approved by the governor. And Representative Coomer is not here to make the motion, but I told him that I would make the motion to strike lines 219 through 222.
Okay. On the Welch Amendment, seconded by Representative Oliver, to delete the lines 219 through 222. Is there any discussion or comment on the amendment? Seeing none, the amendment is adopted.
Mr. Chairman, on lines the following on with Representative Coomer's concerns about there being too much influence in the executive branch with respect to the commission, on line 232, it talks about the remaining 4 members of the commission will be appointed by the governor, and what I would suggest here is rather than the governor, on line 233, that language be inserted, striking governor, inserted president of the Senate and the Speaker of the House, comma, 2 appointees respectively. And that would allow for legislative oversight of this commission.
Could you repeat your amendment, please, sir?
Yes, sir, I will. So where it begins on the amendment is actually to strike the word governor at line 233.
The first word governor?
Yes, the first word governor. I'm sorry, Mr. Chairman, you're correct. The first word governor at line 233, and insert the language president of the Senate and the Speaker of the House, 2 appointees respectively. And that way it would read that going from 232, it would read the remaining 4 members shall be appointed by the President of the Senate and the Speaker of the House, 2 appointees respectively. So we're dividing those 4 appointees up between the House and Senate.
Okay. Motion and second. Is there any comment or discussion on the amendment to line 233? For the clarification, what this does is allows the President of the Senate and the Speaker of the House to have 2 appointees respectively. Each one would appoint 2 people to the Criminal Justice Coordinating Council. And the governor would have, was it 4 appointees? Wait a minute, let's see. And the remaining would be appointed by the 2 would be appointed by the Speaker, 2 appointed by the President of the Senate. Any comment or discussion on the Welch Amendment? Oh, yep. Representative Evans.
A question for Representative Welch. Is it still your intent that the last sentence remains so that the governor is the one establishing the terms? Because the way I read it, if we amend this language, the governor actually won't have any appointments, but we're still putting him in charge of setting the terms.
The way I read that second sentence was that that he needs to set terms of office, and presumably that may be staggered terms. So I was allowing for him to establish when those terms would begin and what those periods of terms would be. And so it technically could be shorter, but I was leaving some discretion there.
Okay, thank you.
Representative Wilkerson.
Thank you, Mr. Chairman. Is it also your intention, Representative Welch, that on lines 240, I guess the governor still appoints the chairperson? Is that still the intent?
That is, yes, sir.
Thank you.
Any further discussion? Any objection to the Welch amendment to line 233? Hearing none, the amendment is adopted.
And then, Mr. Chairman, I also would like to propose amendments to the statement of findings. This deals with the our Georgia Supreme Court, as we had talked about in one of our committee meetings, and I think as also was talked about in short term by Ms. Kristen Widener. I think is that, I may not be said her name correctly. Mary Margaret, is that correct? Widner. And that Georgia Supreme Courts have recognized that there is that local governments can regulate the secondary effects of strip clubs. And that has been associated with the consumption, possession, and use of alcohol on premises. And so I'd like the committee to consider with me some language that would tie that back to that alcohol use as a secondary effect. And so what I would propose is, and this is after some consultation with Ms. Kristen, who cannot be here today because she is actually in school getting her PhD, working on her PhD, I believe. Anyway, on lines 40 of the stated of intent here, after the word nudity on line 40, inserting the language and allows the.
Wait, bring it to on line 40.
Sorry, line 44. Sorry.
Okay.
Lines 44 on page 2. There's lots of words on line 40, but that's not one of them, right? On line 44, after the word nudity and between the nudity and the period, insert the language and allows the consumption. Allows the sale, possession, or consumption of alcohol on premises. Forms of nudity, and so the inserted language would be and allows the sale, possession, or consumption of alcohol on premises.
Okay.
And this would also allow for those strip clubs that do not provide those. If you wish to not be subject to the regulations in here, you would have the out by not selling alcohol, or providing or allowing the consumption of it on premises.
Okay.
And
okay. Could you just read that?
Yes, sir.
Back to us one more time.
So on line 44, after the word nudity, insert the language and allows the sale, possession, or consumption of alcohol on premises.
Period.
That's right. It'll be yes, sir.
Okay. Any discussion? Do I have a second?
Mary Margaret.
Oh, second.
I'm Representative Oliver.
Representative Quick.
Mr. Chairman, thank you.
I'm sorry.
I'm not sure what difference the change in the findings makes in that, because the assessment is against every adult entertainment establishment.
I'll get to that change.
Okay.
I'm going to add that language. Okay. What I just read, I'm going to add that to the other section as well. But you're right.
Representative Evans.
I don't know if anybody on the committee can answer this, but are there any adult entertainment industry establishments that don't sell alcohol? And do we somehow run the sale of alcohol underground as a way for the industry establishments to get around the assessment. That's my concern.
I think it's my intention with this amendment is to be consistent with what our Georgia Supreme Court has already ruled, and also to acknowledge that within the scope of the First Amendment, at the very margins of that freedom of expression allows for nude dancing, or or almost complete nude dancing, and by including the provisions of alcohol, I'm also looking to make sure that we're tying this down so that a club that is purely for the artistic form of expressing oneself through nude dancing would not be subject to this assessment.
If I could ask another question, are you saying that you think that there are establishments that are not what anybody in just normal everyday conversation would call a strip club that you think might be taken into this bill? Is that the concern?
That is the concern.
And what's an example?
I don't have one. But if and this has been, again, this connection, well.
No, I understand wanting to make the connection, and I have the same concern, but I feel like part of the connection that we have is the mere, the establishment of an adult entertainment industry venue causes the activity. I mean, the activity is, it comes, it festers there, sometimes outside, as we've heard today. And so I just worry that the risk of adding that language might outweigh the good intent of the language. And so I don't know at this moment whether I'm going to vote yes or no, but I have those concerns.
Well, I will leave that to the goodwill of the committee, and that's why I thought I would break these up into individual proposals. And if the committee doesn't agree, that's fine. It is just a suggestion for the committee to consider.
Representative Wilkerson.
Thank you, Mr. Chairman. Now, I know this happened a few years ago, but it's my understanding that when you do not sell alcohol, then it allows 18-year-olds to come into the club. So what happens is basically they, like I think it was maybe even in Cobb County where they said that nudity and alcohol, they did not want to go together. So what happened was they were like, that's fine because our business is going to go up because they now allowed 18-year-olds to come into the club. So that may be a side effect of this, is that you have more clubs that do not allow alcohol, but now you have a younger group of people with money that are learning this lifestyle.
That's fair to say. I'm happy to withdraw the amendment if Representative Oliver agrees. So,
Representative Oliver.
I was going to waive.
Okay.
I'll take that as your waiving.
Mr. Chairman, I'll withdraw the amendment.
Okay. It's withdrawn. Okay.
With that, Mr. Chairman, the other amendment that I think that needs to be made in order to make sure that we are being consistent with Representative Atwood's yeoman's work on forfeiture is that we should authorize Ledge Council to double draft this, which is another way of saying that the provisions of this bill will, with dealing with forfeiture, will become effective legally, while also will also be separated out and not affected by Representative Atwood's work on forfeitures to the extent that there's any conflict. And should we need to look at that in code revision next year, we can, but I don't want to get into an issue where we have a signing order problem. We wound up eviscerating some very good language that Representative Estration has put together on forfeitures.
Have any comment or discussion of the motion by Representative Welch? Is there any objection to giving Ms. Travis the artistic license, I think is how it's been referred to double draft the provisions of this bill with respect to forfeiture such that there are no overlapping provisions in conflict.
And I think those two provisions.
What I'm trying to, I didn't know you all were going to vote on this today, and I would like to take one more look at Representative Atwood's bill. And if there's a conflict, I'd like to have the authority to draft to deal with the conflicts. I'm not saying for sure, but I don't know as we sit here. And I'd like to have the authority if y'all are good with it. I spoke to Representative Estration about my concern about that, but I didn't recognize that y'all were taking action today to be prepared.
Any discussion on the motion?
Mr. Chairman, for one, I know we've had a lot of meetings on this, but we've also had a lot of amendments. And if Ms. Travis is drafting other forfeiture language, I would like an opportunity to review the entire committee substitute before voting.
Okay, all right. Well, then that's
so I don't want to cut off anybody's amendments, further amendments, but I would like to review it in its entirety.
Okay. Representative Evans.
Would it be possible, Mr. Chairman, at your discretion, that we continue our work today, because I think a lot of time has been put in today, and if Ms. Travis finds problems, perhaps the bill could be recommitted, but I hate to hold it up just on the maybe there is something, and maybe there won't be. So then we'd have to come back together again.
Well,
let's vote it. There's no more amendments.
There's no more amendments at this point. What we can do.
Didn't have an amendment?
Is there an amendment? Okay. All right. Yes, Representative Waits.
I simply just wanted to remind the committee that we had some unintended consequences many years ago. And my thought process would be to use the word less to make the cap $5,000. I think that would be appropriate.
All right. Where is that?
I believe line 407.
307.
I'm sorry, sir, 307.
Yeah.
And we're simply trying to keep those fees from being
before we get to that, just as a point of order, we have a motion and a second regarding double drafting. Do I hear any objection to the motion and second double draft the bill so that there's no overlap in conflict with provisions related to forfeiture? No objection. Hearing none, the amendment is adopted, or the motion is adopted. Representative Waits, I'm sorry.
So essentially, sir, we would like to move to amend the word and change it from greater to lesser.
And that's on line?
So that would be line 307.
307.
Correct. And again, the reasoning behind that, we don't want to see the fee or the assessment be passed on to the performers or to the workers. That is our concern only.
So remove on line 307, delete the word greater.
And switch it to lesser.
And then, okay, that's the Waits amendment. Here, second. Any objection to the Waits amendment? Okay, all those in favor of the Waits amendment indicate by saying aye. Aye. All opposed, same sign. No. The Waits amendment fails. All right. Okay, is there any other discussion or comment on the bill? We're not not going to have a vote tonight because of the substantial amendments. We will obtain a substitute, and then we'll have a meeting tomorrow, and I will give you notice on that as quick as we can. Thank you very much. Is there any further business? If there's no further business before the committee, this meeting is adjourned.